In view of all the discussions above, claim of the writ petitioner fails. Writ petition is accordingly dismissed. No order is to cost. Interim order, if any, stands vacated.
Deeply over it.
In view of all the discussions held above, writ petitions fail. The prayers made in the writ petitions are found to be devoid of merit. Therefore, the writ petitions are rejected. No order is to cost. Pending IAs are also dismissed.
Right. May I please?
Yeah.
I'm praying for listing of a lawsuit on Friday or what's the next week, Monday.
Subject matter?
Subject matter lawsuit. I have applied for mutation of 10 licenses of land in the sales city portal lawsuit. I have also filed a second appeal. I'll be praying for disposal of my appeal lawsuit.
This is a pending matter.
Pending matter. Similar repetition has been disposed of.
On 10?
10. Obliged.
May I please, Your Lordship, I beg to mention item 22, 23, Lordship. Today, Lordship, I have got some difficulty, Lordship. May take it up next week, any date, Lordship.
22, 23.
20,
21.
21, 22, 23.
Next week.
Next week.
What? Next week? 11?
May I please, Your Lordship. Lordship, I beg
11.
to-
At
I
joint
beg to
request.
mention for
At joint request. Items 20, 21, 22, 23. They listed on 11
Obliged.
of
My lord,
June.
may I say for listing on 12 or 14 matter?
Hmm?
After 10, any date.
Which matter?
Matter, not matter mentioning for listing.
What matter?
Matter compensation.
What compensation?
Road accident. My lord, pass some order.
On 14th.
I am-
List on 14th.
Your Lordship, my lord. My lord, with the consent of magistrate, I beg to mention item number 24 and 25. The matter may be adjourned for 2 days, Lordship. It may come on 7 June, Lordship.
24 and
25.
25.
I am there.
Appearing on behalf of Mr. Anandi Chaudhary, Lordship.
Otherwise, I am prepared my case and there was no intimation given for.
Person from A guy, Mrs. A guy. Yes,
But
sir.
I am the key person here. Seat corporation is a tender matter.
The number.
Not say all pending matter and otherwise become infrastructure in other way.
Sorry?
It's a all pending matter, otherwise become infrastructure in other way. The execution which they have sought for, that has already been done.
So
It's a tender matter.
let us have it on 11. 11.
Not say attempt may be made for disposal, my lord.
At the request of learned counsel for the petitioner, matters and the judge, we listed on 11. Mr. S. Samaria appears for
My lord, seat corporation.
State Corporation. So, an attempt will be made to dispose of
Madam.
the writ petitions on the next day fixed.
Deeply.
Now, the main matter for the Supreme Court that is fixed in July, my lord, just I secure the judgment, my lord, for the lawsuit matter. Because there is one contradictory judgment for which, my lord, the matter has been referred to larger bench. The 5 judges bench, my lord, is hearing the matter. And for that, my lord, this matter was paid and it is pending. If your lawsuit see, my lord, this matter is fixed on 30th July for hearing.
What is the issue about here?
Issue, my lord, that is appointment of arbitrator, my lord. Here, what happened after the amendment, my lord, even, my lord, the ex-employees also cannot be appointed as arbitrator. Secondly, my lord, the person who cannot be arbitrator, he also cannot appoint arbitrator. Here is a general manager who has appointed arbitrator, my lord. He, as per the earlier judgments also, subsequent also, my lord, TRR case, my lord, is actually said that the person who cannot be arbitrator, he cannot appoint arbitrator. But in the central railway, my lord, the case, my lord, it says that when 3 names are given by the general manager, one is selected, he can be appointed. That matter has been referred to larger bench, my lord, 5 judge bench, because there are 3-4 judgments the Supreme Court, my lord, that it cannot be. I can place, my lord, the entire matter also. I think. But the crux of the matter is this, my lord, this matter is pending, my lord, and it is on 30th July. Okay.
Mr. G.N. Sahiwala, learned senior counsel, assisted by Mr. M. Sahiwala. Counsel for the petitioner submits that the core issue in the writ petition regarding appointment of arbitrators is pending disposal in another matter before the Supreme Court. So the issue before the Supreme Court, if decided, will cover the issues in the present writ petition. So it is therefore submitted that the matter before the apex court is fixed for
30th July.
uh, hearing on 30th of July 2024 in civil appeal number 9486-9487/2019 and other connected matters. So, in view of the submissions made by the learned senior counsel, yes, he says the matter is pending before the
Lordship, but no stay order is there. And Lordship, what, how the rate is maintainable, Lordship? I'm raising this opposition also, Lordship.
No, but what is the matter before the apex court? Do you dispute the fact that
Yeah, whether Lordship, this railway employee can be appointed as a retired railway employee can be, but there is no stay order as such, Lordship.
no, obviously, because this is not an appeal against the
Lordship.
the
No,
matter in the SLP is not arising out of this.
Lordship, in one case, Supreme Court stated if there is no stay order, Lordship, then High Court should follow as a, on the basis of the.
Then I can argue also, my lord, there is no difficulty. I
Lordship,
have, my lord, many methods. Because
Lordship,
Supreme Court even state the arbitration award also.
Lordship,
I have
Lordship,
annexed
in view of the section 5, Lordship.
Arbitration award also it has been taken.
There is an order on 5/8/2023
Yes.
where it is recorded that the core issue involved in the writ petition is sub judice
Yes.
before the apex court.
Yes.
It's an inter-party order.
But there is no stay order, Lordship.
No, there is no stay order, but
Lordship,
since the Supreme Court is seized of the core issue,
Yes.
Lordship,
whatever is decided will ultimately be binding.
Para 35. Union Territory of Ladakh versus Jammu and Kashmir. Para 35, Lordship. May I read, Lordship?
Indian territory of
Ladakh,
Yes.
Ladakh versus Jammu and Kashmir. National control. Para 35, Lordship. We are seeing before us judgment and orders by High Court not deciding case on the ground that the leading judgment of this court on this subject is either referred to a larger bench or a review petition relating thereto is pending. We have also come across example of High Court refusing different to judgment of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position in law. We make it absolutely clear that the High Court will proceed to decide matter on the basis of the law as it stands. It is not open unless specifically directed by this court to wait an outcome of a reference or a review petition as the case may be.
No doubt. What is
I have many judgments, my lord. Even arbitration award has been stayed. That was a matter of appeal, my lord. That is different aspect altogether. Our High Court has stayed Supreme Court, my lord. They went to Supreme Court. Supreme Court then
No, the matter before the apex court, does it arise out of this matter? Connected?
no, my lord, connected matter, my lord, because Central Radio Organization case, my lord, Supreme Court held that it can be appointed, my lord, by the general manager. But Supreme Court thereafter, my lord, said that this judgment, doubted that this judgment is not correct. That is why referred to by 3 orders are there. They refer to larger bench. I have annexed those judgment, my lord. That is why, my lord, this Honorable Court has stayed it. Let it be fixed in the August, my lord.
No, not
Second of
August, not August, Lord.
second week of August, my lord. Why not, my lord? This is the main aspect of matter, because if that be so, because I can place, my lord, because our High Court has finally said the matter.
Lordship, this is also 3-judge bench decision, Lordship, of 2023, Lordship.
No, what is pending before the apex court?
The issue whether that retired railway employee can be appointed as arbitrator or not.
Arising out of,
And whether general manager can appoint arbitrators or not.
arising out of what?
Arbitration proceeding, Lordship, arising out of the proceeding of this provision of the GCC by which the railway GM can
No, no,
appoint
Mr.
arbitrator.
Sahiwala submits that this is because of 2 judgments giving conflicting views. Therefore, the matter is referred to a larger bench before the
Larger
apex court.
But Supreme Court in this case has stated that unless there is a stay order, the High Court
Correct,
should not.
but what is the law? Which one? Which of these 2 views will be
No,
binding?
one which is Lordship earlier will prevail, Lordship.
What's the law? In view of 2 judgments of the apex court,
Lordship, the letter judgment I have furnished, Lordship, paragraph 20.
no, you tell us the law that this judgment is prevailing and until and unless it is set aside,
Lordship, paragraph
stay.
20. Lordship, thank you,
Para
paragraph
of
20.
15 of
This Block Asia Pacific Limited versus Union of India.
yes.
May I read paragraph 20, Lordship?
Yes.
This central organization case has been discussed here in Lordship. We will now deal with the last limb of the learned SG submission, which relates to the precedent of the central organization of railway electrification. In this case, clause 64(3)(b) provided for the constitution of an arbitral consisted of 3 members. The appointment procedure contemplated was that the general manager of the appellant was required to nominate the panel of 4 retired employees, out of this which the respondent contractor had to select 2 names. The general manager was required to appoint at least 1 out of the selected officers as the contractor nominee arbitrator and unilaterally appoint the remaining arbitrator as well as the presiding officer to the tribunal. The decision of Perkins was not applicable therein as the contract contemplated a 3-member arbitral tribunal. Well, Perkins applies to the cases of unilateral appointment of sole arbitrator. Further, the court noted that absolutely there is no bar under section 12(5) of the Arbitration and Conciliation Act for appointment of a retired employee to act as an arbitrator. The court in Central Organization of Railway Electrification also relied on the principal elucidated in the case of Western Prime GmbH, wherein DMRC is nominated a 5-member panel comprising names of employees of railways, Central Public Works Department, or public sector undertaking, and the court upheld the nomination inter alia, noting that the empaneling of such retired persons was intended to utilize their technical expertise. In Central Organization of Railway Electrification, these courts relied on the aforementioned judgment, so to that, then this paragraph 27 has been quoted as held in
So this does not answer the submission of the counsel for the petitioner that
Lordship,
there are
is
2
it's
views.
also 3-judge bench, Lordship, and the court case has also been discussed here in Lordship. The Perkins case has
You are
also
not
been
giving
discussed.
us the answer that we are asking you. You're not giving us the answer to the question.
Lordship, the next page may be paragraph 24, Lordship. Next page.
You show us the law.
They cannot be Lordship, they cannot be treated as employee of consultant or advisor of the respondent DMRC. If this contention of the
This
petitioner
is this judgment under consideration
Lordship,
before the apex court.
this is a 3-judge bench, Lordship.
Is it under consideration?
No.
Which judgments are under consideration?
Lordship, that's Tatia, Lordship.
Natya
Tatia construction case, Lordship.
That is the referred to larger
Where
bench.
is it?
That is referred to larger bench, my lord. So, Lordship, take up the petition, my lord, I can place.
Moreover, Lordship, in this case, they themselves have withdrawn the earlier writ petition with the submission that they will refer to arbitration. Thereafter, they submitted an application for appointment of arbitrator. The case has to be distinguished, Lordship.
Where is the judgment which is referred to, larger bench?
Page 116.
116. 14 as well as 16.
114 and 116, Lordship.
Page 116, my lord, they are lost in fine, my lord. Even the award has been stayed by the Supreme Court, which was passed by those. You will say that the award is also wrong. That's page 118. Pending such consider the effect of person of the award is going to remain. Even award has been stayed. Same clause, my lord. Well, answer can say, my lord, that will appeal on different ground. Say it was. Hmm.
Where is the judgment, ECIC, ECI,
Yes, I'm giving.
2019 SCC,
I'm done.
not this. What is the judgment?
You know, 81, my lord. No. Yes. It will okay. I mean, copy this. No. My lord, I have got the copy also.
It's there in the paper book.
Paper book at page 81, but I'm giving it SCC, my lord. That will be better, my lord. Mainly paragraph 37, my lord. That was the draft of the matter. Which is, my lord, under consideration by the law judge. Whereas prior to this, there is a judgment of the Supreme Court, TRF. TRF. Now your lordship will take up Lombard case also, my lord. That is the November 23 judgment. There also, my lord, three judges bench has held. Paragraph 91. Page 60. Down. Paragraph 91.
What was held in this judgment?
Hello?
What was the ratio in this judgment?
Which judgment, my lord?
ECI.
ECI, my lord, held, my lord, that when a panel of four names has been given, then in first case, my lord, the general manager would have appointed, my lord, because the person has selected two names out of that four panel. But the recent, my lord, Lombard case, you'll also
But
see.
general manager himself cannot be an arbitrator.
No,
And
He appoints.
and therefore he also cannot appoint an arbitrator.
appoint arbitrator, my lord. That is that. And the TRF case says that,
So, but
that
then what was held in this judgment?
in the judgment it was held, my lord. Paragraph 37 is the main one.
Hmm.
That's it.
Please read.
Yes,
37.
clause 64 3B, GCC deals with appointed arbitrator when applicability of section 12(5) of the Act has not been waived off. In terms of clause 64 3B, GCC, arbitrator tribunal shall consist of a panel of three retired railway officers retired not below the rank of senior administrative grade officers as arbiters. For this purpose, railway will send a panel of at least four names, panel of four retired arbiters employed to work the arbitrators, indicating their retirement date of contractor within 60 days from the date of when written and valid demand for arbitration is received by the general manager. The contractor will actually ask the general manager at least two names out of the panel for appointment of the contractor's nominee within 30 days from the date of dispatch of the request of the railway. The general manager shall appoint at least one out of them as the contractor's nominee and will simultaneously appointing the remaining arbitrators from the panel or from outside the panel, duly indicating the presiding officer from the amongst of the arbiters. The exercise of the appointment of arbitral tribunal shall be completed within 30 days from the date of receipt of the names of contractor nominee. Thus, the right of the general manager in formation of the arbitral tribunal is counterbalanced. Well, this is the only thing. Counterbalanced by the respondent's power to choose. Where do we choose? They have given our names. It is not my selection, my lord. It is their names they have given. By two out of from the four names, and general manager appoint at least one out of them.
No, in the facts of this case, there was a choice.
That is the same thing, my lord. This has been challenged, my lord. This matter has been referred to larger bench. If your lordship see Tantia, if your lordship see Tantia, my lord. Yes.
No, kindly see para 37.
Yeah.
In the middle,
Ah.
the contractor will be asked to suggest.
Yes. This is, my lord, this is appellate clause.
This is a mandate of what? The GCC.
GCC. This is the crux of the matter, my lord, for which the matter has been referred to larger bench. And now Tantia, your lordship see page 115, my lord, Tantia case. If your lordship see him. That is why, my lord, this matter has been referred to larger bench. General manager himself is incapacitated, my lord. That is Tantia's case. If your lordship see page 114 of the petition. I shall place it. Now, at page 114, my lord, your lordship must just take, I can test, my lord. Page 114. Your lordship got it, my lord?
Yes.
However, reliance has been placed, fourth line, upon the three judges bench decision of the court delivered on so and so. This judgment. We have produced the aforesaid judgment and permanently disagree with it for the basic reason that once the appointing authority itself is incapacitated, or general manager is incapacitated, my lord.
This
Once the
re-
appointing
this
authority itself is incapacitated,
The
the appointing-
reference is, there is no dispute that the reference has been made for
Yes.
larger bench.
Yes.
But why was the judgment considered to be requiring a reference for reconsideration?
my lord, because the general manager is incapacitated. TRF judgment I have said, my lord, placed before your lordship. Earlier judgment, TRF case, my lord, if your lordship see page 54, TRF case I have placed, my lord. 17.8 SEC 377. TRF case. I have given a
76.
copy, my lord.
76.
No, 17. No, my lord, the party I have given a judgment, my lord. 2017 8 SEC.
Yes.
78.
Yes.
Page, last page, paragraph 54. Last page, paragraph 54. my lord. TRF case, your lordship, my lord.
Yes.
In such context, the fulcrum of controversy would be, can ineligible arbitrator, like managing director, nominate an arbitrator who may otherwise be eligible and a respectable person. As stated earlier, we are neither concerned to objectivity nor individual respectability. We are only concerned to authority or the power of the managing director. By our analysis, we are obligated
to nominate a serving employee of the Union of India as the sole arbitrator. Such a expression clearly is distinct from the arbitration clause and as in this conflict with the when the person judgment
It is not a railway.
and referred to a large bench in
It is not of railway.
was not in the present case. In this process, also we have no guidance of the
Not of that. The paragraph 21 is clear.
21 rather says
Hmm.
this is in conflict with 12.5.
Yes,
But a central organization case has been
No, you see, you read para 21.
in contrast, the
21.
arbitration clause in the present case enables a serving employee of the Union of India, a party to the contract, to nominate a serving employee of the Union of India as a sole arbitrator.
This is their
Such a-
position here.
To nominate such an authorization is clearly distinct from the arbitration clause in the Vice line GmbH and central organization, and it is in conflict with section 12(5) of the Act. It
It
was
is in conflict.
informed about that the correctness of the judgment of the so-and-so has been challenged and referred to a larger bench in so-and-so. As well as in so-and-so, we have noticed that the decision center is not applicable in the present case. It is reference to. But no,
Says it is in
now I am on two basis lordship. But
Huh?
this case is distinguished in the sense because they themselves has asked for arbitrator. Then we,
para 21 has
Lordship.
referred to.
and since there is a no stay order lordship,
What are you saying,
On
Mr.
that-
Counsel? We are trying to ask you whether the judgments are covered. If it is covered, then the law is in their favor. If you want, we proceed with the hearing. The judgment which you have referred has clearly held that
lordship,
the power to appoint an arbitrator by a person who is not competent to be an arbitrator is in conflict with 12.5. This is what I understand from para 21. Subject to correction.
lordship.
even our High Court has, my lord, appointed some judges as an arbitrator, my lord, in railway case. I have got a copy there. Supreme Court has appointed in 3 cases, my lord, Supreme Court judges as arbitrator. Without, my lord,
So what is the implication you are trying?
implication that, my lord, that clause cannot be, my lord, implemented. General manager cannot appoint, my lord. General manager cannot appoint. One of our High Court, my lord, judgment I can.
That is what we are trying to find out. The judgment which you are relying, tell us that it means something else.
So that is why, my lord, my humble submission, my lord, that let the matter be fixed in the middle of August, my lord, everything will be clear, my lord.
Not August, lordship in the
I am
after
ready to
reopening.
take up today, subject to both parties agreeing that yes, it can be decided. But at the end of the hearing, don't tell me that the matter is pending before the Supreme Court, so may be different.
My submission is lordship, this case is distinguishable in the sense that they themselves approach for arbitration lordship.
That is what
And-
has been held to be contrary to 12.5 in
Since
the
there is
earlier
no,
judgment.
since there is no stay order lordship.
No, what stay order?
The issue is since lordship, the issue is pending since 21 lordship.
No.
So how long
The
lordship?
judgment which has been referred for larger bench, that is
Central organization case.
central organization, there also that distinction was made
Lordship.
that because a choice was given by the party, it counterbalanced the power of the authority to appoint.
Lordship.
That was held to be, that was doubted in the subsequent judgment, and therefore the matter is before a larger bench. But notwithstanding that view, there are at least 2 judgments which support the contention
Let,
of the
lordship,
petition.
let us wait for some, the Supreme Court may decide after the reopening lordship. Let's wait, hope so.
Huh?
Lordship fixed in the month of July.
See, that was the submission made by the council in the first instance, and you objected.
Because in view of lordship, that since there is no stay order, that's why I,
What stay order? I don't understand. What stay
lordship,
order?
that the decision I have relied on lordship, the Jammu and Kashmir case, in which
No,
Supreme
stay
Court
order
stated, until
where?
there is a stay order,
Stay order where?
all the proceeding.
Obviously, does it require a precedent?
Yes, lordship, that is what has been stated in that judgment, lordship.
My lord, arbitrator award has been stayed, which has been delivered by this panel of arbitrators. That has been
You
stayed.
tell us if you want us to proceed, we'll proceed with the hearing.
Last we fixed in the last week of July, Lord.
It is submitted by learned counsel for the parties that take a look. In this writ petition, under this is under 11.6.
No, Lordship,
12.
226, Lordship.
Okay.
This is a
So 12,
petition under
226.
226, Lordship. That is also a
11,
question, Lordship, whether
this writ petition,
226 is maintainable or not.
the question of appointment of an arbitrator by the general manager of the railways with respect of a contract by and between the petitioner and the railways is an issue. Stop. According to the writ petitioners under provisions of section 12
Five.
of the Arbitration and Conciliation Act 2016, an authority who's not competent
To be able.
to be appointed as an arbitrator is also not competent to make a reference, is also not competent to appoint any other authority as an arbitrator. Stop. It is submitted that this view is covered by the judgment of the apex court in TRF, reported in so and so, and Parkins Eastman, reported in so and so. The learned senior counsel further submits that the a subsequent judgment rendered in Central Organization for Railway Electrification, reported in 2020, 14 SCC 712, had upheld a similar nomination by the Railway Authority on the grounds and reasons mentioned therein. Stop. In a still later judgment, later proceeding before the apex court, rendered it, what is that judgment? 114.
Yes. 114, 116.
In Messrs. Tatia Constructions Limited, Civil Appeals number 12670/2020. Sorry, this is not civil appeal. Petitions for SLP numbers 1260/2020. By order dated 11/1/2021, a three-judge bench of the apex court doubted the correctness of the judgment of the apex court rendered in Central Organization for Railway Electrification, reported in Supra. And a request was made for placing / reconsideration of the said judgment by a larger bench. Stop. Learned senior counsel submits that the matter is presently pending before the larger bench has
Yes,
been
sir.
constituted.
Constituted, my lord. That is on 30th July, it will be fixed. Everything has
And,
been completed
has
before that.
been already constituted, and the matter is placed before the larger bench. And by order dated
16/4/2024.
16/4/2024, in civil appeal number 9486-9487/2019. The matters have been listed for hearing on 30 July 2024. So, learned counsel, senior counsel for the petitioner submits that since the core issue of whether an authority who's barred under section 12(5) of the Arbitration and Conciliation Act to act as an arbitrator would otherwise be competent to nominate an arbitrator is an issue which is required, which is pending disposal, and which is pending a decision for the apex court in Central Organization for Railway Electrification. Stop. The same issue is also raised in the present petition, and therefore the learned senior counsel submits that the matter be listed after in the month of August. So, there are Mr. B. Chakraborty, learned CBC, although initially objected to the prayers made on the ground that there is no stay order. There is no stay of any of the proceeding by the apex court in the by its order dated 16/4/2024, and the writ court is otherwise competent to proceed and hear the matter. However, submitted that, however, fairly submits that the issue presently pending before the apex court is will have relevance in deciding the present issue before this court. So, he, however, objects that this is the writ petition which is filed questioning the appointment of arbitrator by the railways, and the question of whether the writ petition is maintainable at the first instance, or the parties are to be relegated to file an appeal under section 34 is also a question to be decided. So, upon hearing the learned counsel for the parties, let the matter be listed on 5th of August. On 5th of August, by which time the parties will apprise the court about the status of the apex matter before the apex court in central organization for railway electrification.
The interim order will continue, my lord.
The interim order passed earlier will continue until further notice. But then this is a question you will have to again answer, whether a writ is maintainable.
My lord, I have that. I have a judgment of the court.
In this matter, my lord, petitioner has prayed for defreezing the account, my lord, bank account, my lord.
My salary account has been.
Yes.
We have filed affidavit. As per our affidavit, search it has already been submitted, my lord, and the procedure has also been made in respect of that investigation purpose, my lord. So let me have appropriate instructions, updated instruction, whether any requirement is there for further defreezing or not from the investigating officer, my lord.
Defreezing is on the basis of what?
That some
Request,
monetary
request made by the
IO, my investigating officer to the bank authorities. So if there is no requirement, let me have instruction, my lord, for 1 week time might be granted. On the basis of that, my lord may pass necessary.
What is it?
Some transactions were made.
Well, for that may be given because I am occurring
Third learned counsel for party.
your financial hardship.
Petitioner is before this court, praying for a direction to defreeze the salary account of the writ petitioner, which has been frozen.
Pursuant to summary PS case number 325.
A request made by the IO in connection with where is the reference of the case?
In synopsis is also there. Summary PS case number 325/20.
Chanmari PS case number 325 of 2023 under section 11. So, learned government advocate submits that the charge sheet has been filed.
Yes, my lord.
In
We
the
have
matter.
filed affidavit. As per our stand,
the
charge sheet has already been filed
Same
on
is also reflected in
24
the
to my lord.
affidavit filed by the respondent number 2.
Para
So,
5 we have mentioned.
accordingly, since the charge sheet has already been filed and the court is in, the trial court is seized of the matter, the respondents will apprise the court as to whether the account of the writ petitioner is still required to be account of the writ petitioner can be, if not required for further investigation, can be made operative to enable the writ petitioner to operate his account. So, such instructions be placed before the court on
14th, my
14th. On 14th. It's recording.
Bibliography.
In this case, Lordship, new incumbent Dilip Karmakar has joined the post as Deputy Director, Food and Civil Supply for Technology. Now we want to bid him.
MSP Somlar and Council American commits that new incumbent in the post of Deputy Director Food and Civil Supplies has been is required to be impleted. The party responded. Therefore, submits that she be permitted to file necessary application seeking implement of the incumbent. Prayer made is not objected to by council respondent. Therefore, had to be listed after 3 weeks.
No, Lordship, that next week.
Next week,
Lordship,
all right, be listed after 1 week.
Biblia,
May please, Your Lordship may kindly grant us 2 weeks' time to file our affidavit.
Who are you?
I'm for respondent number 6 on behalf of Senior Counsel B.D. Das.
Last occasion on 15/5, respondent number 6 set time 3 weeks to file the affidavit, and the Pharmacy Council also they set time to file the affidavit.
You're putting to challenge what?
This is election.
Yes, Mr. Das.
My Lord, we
Affidavit
will
not
get-
on record.
We will have to file affidavit within 2 weeks' time. Otherwise, it's an election dispute, my Lord, appeal lies under section 24 of the my Lord, Pharmacy Act before the government.
You file your affidavit.
I'll
you-
file within 2 weeks. Sir.
2 weeks. Respondent councils pray for 2 week further time to file their affidavit.
Government is also filing, my Lord, within this week.
Accordingly, let the matter be listed again on 24th June. It is the respondents will file their positively file their affidavit by the next 6 weeks.
I think we can file it within a week time. This week we'll be filing.
Mr. P. Monto for the petitioner, Mr. P. D. Das, assisted by Mr.
Jamie Lotha.
J.B. Lotha, appears the respondents. Mr. A. Cholia for respondent for.
Look,
Are you required to file an affidavit?
Yeah.
The respondent number 4 will also file an affidavit.
actually under section 24, my Lord. Government is the authority to,
We
Look
filed,
into
my Lord,
it.
that was not considered, madam.
then you will have to challenge it.
All right.
Good.
May it please your lordship. Lordship, in this matter, we want to file the reply to the additional affidavit filed by the petitioners lordship in WPC 3422, 2020.
These are what transport workers.
Yes, sir. Lordship has substantially heard the matter.
Uh, was it hard?
Yes, Lordship. In fact, senior counsel with the KM Chudhary elaborately made a submission. And in
What
fact,
do
Mr.
you want to file?
Lordship, a reply to the additional affidavit lordship, which was filed on 8/4 lordship. We'll file a reply.
There is an additional affidavit filed by the petitioner showing that in our place, now they are recruiting people on an ad hoc basis. They want to reply to
Additional affidavit filed by
In item number 5 lordship, WPC 3422.
Board of Yes, any objection?
But let them take a short day.
Respondent of may be filed. Yes, reply. Sorry, reply affidavit. Prayer made this after 6. I don't know. It is not that. Yes.
Lordship is keeping it short.
Let them file their pleading.
Lordship may pray for a fixed day. Any date for
24th.
Lordship, it's slightly before Lordship on 20th, Lordship, it's a hearing day.
20.
20th.
20, Lordship.
But will it be 2 weeks? So pray for
Lordship, it'll be 2 weeks, Lordship. Today is 4th.
all right.
Lordship.
20 to remaining.
No, respect. Otherwise, Lordship,
No, Lordship, let it be before the vacation.
2 weeks.
On 20th, Lordship. All right.
DP.
It's also a long pending matter.
Based on like may this matter be taken up after some time.
It's another date, my lord. I don't know how much time it will take. In fact, Lordship
Counsel
has
for the
heard this
petitioner
matter.
submits that the arguing counsel not available to argue the matter. Respondent Mr. S. Tamaria submits that the matter
Can-
be listed on some other date. According, let the matter be listed in the month of July. Let it be in the month of
Date can be fixed as the petitioner is already been retired.
let it be in July,
Yes, nothing by otherwise.
July
Main,
17,
main prayer is, my lord.
17 July. What? Huh? Good. They do.